It's law time on this Thursday morning. Our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, with us each and every Thursday just after 8:30 New South Wales time. To offer her legal expertise, she provides some general advice on the latest hot topics. She has experience that spans more than 25 years in areas of property and commercial law. She also prepares wills as part of estate planning and litigation. With us once again, hi Despina.
Hi, Wayne. Hi, Brooke.
Good morning, Desi. Good morning, Mano. So first off this morning on Talking Law, we'll kick it off with a question from Scotty in Tweed Heads. He got in touch recently and he wanted to know because we have been speaking about wills recently, especially in the last show, but he wanted to know if you already have a will, Despina, can it easily be changed? If something comes up and you want to make some sort of amendment, can you do that? Or do you have to create a whole new will?
Good question.
Okay. Great question. Thanks, Scotty, for that question. So you can make changes to your will, but it's how you do it. Okay. So we don't want to grab the will that we might have at home, if it is the original will, or even a copy of your signed will, thinking, I'm going to go and make some handwritten changes. I'm going to write all over it, and that's going to fix it. Well, no, we don't want to do that, because if you do that, if it's the original will, it's invalid. But also, if you grab a copy of a will and make all these handwritten changes, you're going to cause confusion with maybe the court later on, because the court might think there's supposed to be a valid will and it's not really. So the short answer is you can make changes. Now, you can do it in one of two ways. You can sign a document called a codicil, which is the official term for an alteration to a will. Okay. And that's probably the best way, where you have very, very small changes. For example, I just want to change one executor, so that's a very simple change. So you just sign a codicil. Now, a codicil has to be signed in the same way that a will does. So you need to sign it in the presence of two independent witnesses who aren't beneficiaries. So it has to be done in the same way as a will. Or if you've got quite a few changes, it can get quite messy to do a codicil. So sometimes it's best just to start again and do a nice, fresh, clean new will.
Okay. And presumably it would be cheaper if you're getting someone to make those small changes than starting from scratch.
Yes, so obviously a codicil should be cheaper, but then, as I said, if you've got quite a few changes, trying to marry the codicil up with the will, if there's quite a few, can get messy. That's why it's always better, I think, to start a clean, fresh, new will if there's quite a few. So yeah, I hope that answers the Scotty's question.
Perfect. Thank you, Despina. I hope you got that, Scotty in Tweed. Thank you for sending that in. And now moving on now to our first hot topic this morning. It's a juicy one. We're talking about unfair contract terms regime. Now, big changes are happening as of next Thursday, the 9th of November, for business owners specifically all across Australia. So, Despina, can you talk us through what these changes are?
Yes, so I've left it, I suppose, a week before, haven't I? To actually mention this on air, but I'm assuming that lots of consumers and business owners are aware of the changes through different regulatory bodies. But my question to people out there is, are you ready for these changes? Because they're massive. And what it's actually going to affect is a bigger, larger pool of consumers and business owners than what we currently have. And we want to talk about how it works, what businesses does it apply to, what types of contracts are you talking about, so people out there can understand if it affects them. So everyone that has a business should be listening up, regardless of the size and regardless of what type of business it is, to see if you're going to be caught, because there'll be many businesses that will be caught under the changes to the new regime. And there's some massive penalties coming out. So that's why you want to listen up, to make sure that you want to see if you're caught under the regime and what you need to do. So the unfair contract terms regime. So we currently have laws which say basically that for certain small business contracts, certain contracts cannot have, or those contracts cannot have, unfair contract terms. And if they do have unfair contract terms, and we'll talk about some examples in a minute, those terms are basically void. So that's what the current law says. So if you're given a contract and it's discovered that one of the terms is unfair, then currently it just says, well, it's a void term. So everyone goes, oh, okay, well, we can't really
Just forget
enforce
about it for
We
now.
don't care. We'll
Yeah.
keep going, doing what we're doing.
Exactly. So no, as of next week, that's changing completely. So not only is the pool of the consumers that this is being targeted to is increasing, and we'll talk about the threshold, but also the massive civil penalties that will apply if you use standard terms, contracts that have unfair contract terms, and if you even propose a standard contract to consumers that have unfair contract terms. So not even one that's entered into. So you're proposing it, but you also have consumers entering into a standard term, standard template contract that have unfair contract terms. And first of all, what are we talking about? So we're talking about contracts that are standard contracts. So what do I mean by that? So if you have a business where you're using standardized agreements for, here's my standard terms and conditions, my supply agreement, my terms of trade, things like that, which many businesses would have. If you're going to a builder and having a builder give you a build contract that they use all the time, like a standardized build contract, they will be caught. If you're buying off the plan contracts, for example, from a developer uses standard forms of contract, they will be caught. So it's really where a business uses a particular type of contract on multiple occasions for their business. So it's called a standardized or standard form of contract. Okay, so it's not really a bespoke agreement we're talking about.
Can you give us just a couple of examples of what you're talking about here that might be caught under these changes?
So we'll talk about some examples of what an unfair contract term might be in these standard forms of contract. Yes, we're going to talk about that. But first of all, let's talk about the threshold. So who is caught? So that's what we want to sort of focus on initially. So after the 9th of November, the pool of consumers is being extended. So now the current law say if you have a business with 20 or less employees, you're going to be under that regime. After the 9th of November, that's changing to businesses that have 100 or less employees. So you're going from 20 employees to 100 employees. Now that's huge. So therefore, the pool of business owners is going to be very, very wide now.
Massive.
Very wide. Okay, so the other test is the turnover. So if you have a turnover for the preceding income year, that's less than 10 million. That's the other test. And we're talking about it in our industry, and we're saying, look, probably businesses will just use the employee test because that's an easier test. It's quantifiable. You can just count your employees. Part-time employees will count on a pro rata basis. Casual employees will not count unless they're on a regular and systematic basis in the business. So that's your test. Okay. And whereas the current laws say that, look, if you have a contract that's under 300,000, that's the threshold, you will be caught. If the value of the contract is over 300,000, you won't be caught. Now that's going. There's not going to be any threshold anymore. So,
all right. So potentially there'll be thousands more businesses will be
absolutely
now under these new rules. Yeah.
Absolutely. So thousands of more businesses will be caught.
Do these business owners get some sort of email or letter going out being like, hey, you only have...
Yeah, you might want to know about this.
Like, you only have 50 employees, but get ready because it's about to get crazy up in here and all these rules are coming in. Is there some sort of, I don't know, group email to all these business owners that don't know about this?
I would expect ASIC would have done that. I would have expected the ACCC, and I would expect also the state's Office of Fair Trading would have issued publications and notices to business owners. Absolutely. But if you haven't or you don't know about these laws, believe me when I tell you they are commencing next week. And so why do we want to know? Because the civil penalties are huge. So like I said, if you enter into or have your standardized repeat usage of a contract in your business, like supply agreements, terms of trade, things like that, build contracts, like I said, off the plan contracts, if you use them after the 9th and they contain unfair contract terms, well, not only is the term going to be void, well, wait for it, massive civil penalties. Massive, they're huge. So if you can have them in there, these are the penalties that are going to apply. So for a company, stand by. Maximum penalty we're talking about up to. So the maximum for companies, we're talking about the greater of $50 million.
Ooh, yep.
Yep.
Oh my goodness.
Or 3 times the benefit that the company obtained because they used an unfair contract term, or 30% of the adjusted turnover of that company. So that's for companies and bodies corporate. For individuals, the maximum is up to 2.5 million. Now, in addition to those massive civil penalties, if you have a standardized contract, it contains unfair contract terms, and you use those and have consumers sign them after the 9th. So that's what we're talking about. Not only do you or may you face those penalties, but there are other remedies that the court will have available to it. For example, the court could order things like, well, I'm going to order that you cannot use these contracts anymore in your business in the future. And that's a pretty big deal. The court can also order that the whole contract is unenforceable. So that's also a very big deal. So the remedies are much wider for the court. There's going to be civil penalties that are already built into the legislation as of next week if you have contracts that you use after the 9th, that you have people sign that have unfair contract terms. So very, very important for business owners to understand this, whether you're individual or company. Now, what are some examples? So that's what we also want to get to, because people might be saying, well, what's an unfair contract term anyway? You know, and I need to know and I need to understand, because what I'm saying today is you need to go through all your standardized agreements if you haven't already. Go through that process as a business owner and start to tweak and change or maybe revamp the entire agreement if it's full of unfair contract terms, and start again and issue fresh, because you don't want to be caught under this regime with massive penalties you could be facing. So some examples. Okay, you've got clauses that permit one party only to terminate a contract. So we've talked about that before, where, you know, only one party has rights, but the other party doesn't have the same rights. So you've got one party that has the right only to vary terms of contract, but the other party doesn't. One party that can vary a price in a contract, the other party doesn't. So there's these, you know, automatic rights and unilateral rights that might be given to one party, but the other party doesn't have that. They just have to take it or leave it. You know, if a company says take it or leave it, my conditions, it is what it is. Well, you know, that's already a red flag to go, oh, what are your terms anyway? Because I know as of the 9th of November, being a consumer, that now you're going to be subject to massive penalties if you give me an agreement or, you know, a supply agreement in terms of trade that have unfair contract terms. The other thing is if you're not given the opportunity to negotiate. That's really important. So, you know, as I said, take it or leave it. Well, no, I get to negotiate what I consider fair. And that doesn't mean you get to rewrite someone's agreement, but it does mean that you can go to that business owner and say, look, I need to have an opportunity to read, to review, and maybe amend if you've got some unfair contract terms or things that are unreasonable. So what other examples? Broad indemnities in favor of only one party and not the other. So that sometimes often happens when you have agreements. So when you're reading through, you want to have reciprocal rights. You know, what applies to this person should also apply to that person. Unfair payment terms. So that's another example, you know, unfair payment terms. Really, really important. Unduly short periods of time to notify a party of an event. So something that says, okay, you've only got 2 business days to tell me, or, you know, 3 days. Well, is that unfair? Is it too short? Should it be 7 days? Should it be 14? So those sorts of examples are really, really important. Also, what's really interesting is agreements that say, or that they're called an entire agreement clause. So most agreements say it. So what the clause basically says is this agreement has all the terms and conditions that we've talked about. That's why it's called an entire agreement clause. So anything that we might have talked about before, anything that you and I might have negotiated does not form part of this contract at all. Those types of clauses potentially now are seen as unfair contract terms, which is really, really important because most agreements contain an entire agreement clause. Basically, you know, if you negotiate a term with someone and you're going into a contract relying on what that person said or represented, and the agreement says, yeah, but whatever I told you before, it doesn't matter. It's not part of your contract. Oh, really? I don't know about that.
Not good.
No. So there's a lot to understand, lots to go through as a consumer and a business owner between now and next week.
Yeah, only a week away.
And just lastly, Despina, is this a case of the consumer having to report the business owner or the company if something does look dodgy, or do you suspect that there might be investigations underway as of next week?
That's right. So we expect the ACCC and ASIC to start enforcing and making inquiries as to whether companies are using unfair contract terms as part of their business. So we are expecting that enforcement regime to kick in. As to what that looks like, we'll have to wait and see.
Yeah, Thursday, the 9th of November. Write it in your diary. Maybe do some investigating yourself if you're a business owner. Coming up next, the biggest overhaul to property law in Queensland in 50 years. This is incredible news. Despina has all the details coming up on Talking Law in just a moment. Stay tuned.
Are you confused about legal jargon? Do you need legal advice but don't know where to turn? Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97. Despina, a leading lawyer with over 20 years of experience, will demystify the law and provide practical advice to help you navigate legal issues. Whether it's a family matter, a property dispute, or a business concern, Talking Law has got you covered. Don't miss out on this valuable resource. Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97.